any additional information that might help security or so. Is that possible at some time tonight?
Yeah, but I'm working on something with that, so I'm sure to release it. I might want to talk to you privately about it.
That's fine too. You got my number, right? Or Al's got it?
Yeah, I got it.
Okay, all right. I'm usually here. We're actually creating a small private group out here in California. I've got a manual on land patents. Oh my God, this manual is absolutely delicious. It's just amazing. I had hardly even a clue of some of the research this gentleman did. He started 28 years ago on this on his land patent venture. I used his documents, and they're beautiful.
What I've found out is that most of these people don't know that it's been operating as a trust, and here the trust was blocking the coming forward.
Well, the other part about it is that with the Guadalupe Hidalgo Treaty, it says the amendment, which is the Protocol of Quintaros, was after the fact of the Guadalupe Hidalgo Treaty signing, that it wouldn't be ratified unless this amendment was put in there, and that said that all pre-established land patents by the Spanish-Mexican countries would not be overturned and or eliminated, that they would stand forever, of which they have. And it also stipulates that they cannot put any kind of a lien and or any kind of a claim, such as public offices or taxation upon those lands, of which they have in California. So this is going to get real.
Kevin. Lenore in Minneapolis.
Hello.
Hi.
Eric in Florida.
Hello.
Eric, how you doing?
Great, thanks. Hey, is this going to be a question and answer call from the beginning, or do you have something you're going to talk about for a while, or what you got in mind?
Q&A, probably Q&A, yeah.
Great, because I got something. Are we waiting before we bring a bunch of people on, or are you ready to get started?
No, I'm ready. Yeah, we might as well go ahead.
All right. I was reading in Gilbert's about the relationships distinguished from trusts, such as bailment and transfers and agency and liability and termination. No, that's under agency. I'm sorry, and under debtor-creditor. And if you could, because it really becomes gray on some of these other things in reading. It was on page 6 and 7 in Gilbert's. And start reading some of that, it's really hard to distinguish, to have a clear line in the sand when we're distinguishing some of these relationships that are not trust. But as I'm reading it, like, for example, the bailment stuff, for example, it says, where the owner of tangible personal property gives possession but not title to another. The relationship was one of bailment, but because there's no real lawful money, is it all trust anyway?
Yeah, it's all trust anyway.
So really, to read this, we got to take it only on the statutory side, really under debtor-creditor, because we can express them all as a trust, is the long and the short of it. Huh?
Yep, everything can be expressed as a trust, except you're the one that volunteers to go under the debtor-creditor because you didn't express a trust.
Okay. Well, I was right when I was reading it, because I'm reading it and I'm looking at all these going, but they all seem like trust to me.
Yeah, although they're going to distinguish it, differently under the public forum, they're going to sit there and say, well, it's debtor-creditor or whatever, and you owe. And they've got all the information created, which basically you created through your signatures anyway. And if you've got the records created that it's otherwise, then you can rebut that.
And all that really is the ellipsis, right?
Yeah, just the 3 dots from the minimal. Yeah. In fact, you really, if you knew your stuff, you wouldn't even need the 3 dots, because it comes back down to intent. And the only party that can get you off track is you yourself. You're the only one who can confirm your intent and purpose. Nobody else can.
As king, right?
Yeah, so if you're asking the questions and you understand and have the knowledge what you were doing, you were setting up a trust, then it was your intent and your purpose to set up a trust. A trust could be set up, formed, and operating solely under a trust, and none of the parties really knew. Let's put it this way, let's say maybe you did know as grantor, and the other parties might not have known. But that doesn't negate the fact that a trust had been legally formed, it was operating, and as long as there was no breach that you had to enforce, then, all the parties wouldn't have to necessarily know.
One of the recurring things that I think we're finding, phone call to phone call to phone call, is when people are expressing, one of the things that I think people are concerned about is if the judge disclaims, for example, in a court case, and it's not our job to teach him the law, because as a judge he should certainly know, but he still may state that he doesn't have he doesn't have to take on the role of trustee. So just wondering what the best way is to handle that situation when we express as grantor and beneficiary, and how to pin him down or her down in that type of situation.
Well, I would ask him, Judge, are you aware that equity will not allow the trust to fail for lack of trustee?
And being in chambers, that's exactly where you are, right?
And I would remind him of the fact that a resulting trust is formed, and now you must appoint a successor trustee, and when you do, let me know who that is, their name and address, so I can complete the transaction and give them trust res property.
And of course, the only thing that the equity court knows is he's guilty until he makes a payment at that point, or assigns a successor trustee.
Yes, because I'd hate to bring him up on some kind of obstruction charges for not allowing the trust to be completed. So I would point out the fact that his duty was to appoint a successor trustee because a trust exists.
Would you really hate to bring him up on those charges, Christian?
I don't really want to break everybody's arm, but if I had to, yeah.
Just like they do to us, of course, right?
Yeah, that's true, right.
They might not want
to nail you to the wall.
And when one of the things that me and a few other people are working on is a federal civil complaint to get our ticket into the court and create an estoppel. If you were creating a complaint, going in with the frame of mind to get into the in-camera, is there anything you would include or be thinking of while you're creating that complaint in the way that you're structuring it to keep in mind all the way through?
Well, I would have to make sure that I got the necessary elements under that cause of action. And whatever the cause of action was, whether it would be multiple ones or whatever, that would be the focus. Whether it be breach of trust or duty or something else, or an unclean hand, say, or whatever.
Maybe I should ask the question a different way. Because our goal is to get in camera, is there anything that you'd structure the complaint with that, beginning with the end in mind?
Structure the complaint with... Maybe I'm kind of missing your question. You mean the protective elements in there and stuff?
Well, no, the protective element, the protective order would be a separate document altogether, obviously. No, what I'm getting at is that when we're actually creating our separate causes on this complaint, and we're writing our opening paragraph and our closing paragraph, is there anything you'd theme through there, knowing that eventually we're going to be in camera, that you would keep in mind that we could use, or we would want to include in that document, knowing that's where we're going to be, because that's the end we're certainly shooting for?
No, I can't think of anything that's specifically other than what would be used in chambers to be included in on the public side motion. You mean?
I don't know. I'm just looking because we're about to write this complaint, and I'm doing it based on the document that they put in the jurisdictionary. I don't know if you're familiar with the stuff that I wrote. Are you?
I'm not. No.
Okay, I'll have to send that to you. But it's really pretty. The idea behind it is to be as concise as possible, use as few words as possible to convey your idea, and don't make it 30 pages. Make it 5 if you can, because you have a much better chance of actually getting some type of relief. And one of the things that they talk about in there is that's your best opportunity to compel discovery of all the different things that you're after, and you want to do that from the very beginning. And because they were sharing that with me, I thought to myself, okay, beyond that, what can I ask Christian to do as far as from the beginning, knowing I'm going to wind up in camera, or I'm shooting to get in camera? Is there anything I want to utilize to from the very beginning, so I don't miss any opportunities that I'm unaware of?
Well, I think I would make sure that it was colorable on the public side, so that it would kind of like hide the fact that I'm in chambers and that. So I'm playing a dual game, a public-private game, but yeah, I'm trying to keep it, as colorable as possible, that they can recognize the colorable side. So I get enough stuff in there that, is going to allow them to save face, as I usually say. Remedy out. Okay,
there's some pay dirt. So an out for them might be really important that we want to keep in mind. So they have a way out, because if we give them that, then we're much more likely to get relief. Yeah, I think that get these judges between a rock and a hard spot in their trust, and they're going to be looking for a way out. And I'm going to, give them that option that I want them to take. But I'm going to put it, colorably, give some way to give them, so they can save face, the case, or so you can win.
Can you give us a sample?
Got some background noise. If anybody's not speaking much, press *6 and mute out. There we go. Thank you.
And one of the other things that's been talked about on some calls in the past is both on a civil and a criminal case, there are bonds that are in the background that play a role in these cases. Now, would it be right to say that the bonds, that the court files is, and of course we know that all the courts are listed on Dun & Bradstreet as corporations, so would that be fair to say that those bonds are their confidential commercial information?
No, I would say that is our confidential commercial information, because those bonds are actually drawn from my signature, and they're the proceeds from my signature, and they're mine.
Okay. So, but either way, because they are CCI, it would be a disclosure of the CCI if we were to bring it up in the outlaw side. So it would be nothing but a way to waive our CCI if we were to bring anything about that up in the outlaw in the color side.
Yeah, I wouldn't want to do that. I would keep that for the private side. Yeah.
Okay. And then when we do get into the private, how would we want to bring up the fact that the bonds are there in the case? Do I just compel the trustee to produce the records and then make a decision and for him to make payment, or just simply instruct for the trustee to make the payment?
Well, there you go. Statement of accounting on the trust. I want to see all the transactions that were made by the trustee.
Okay. And as beneficiary, we have every right to demand that under.
Yes, you do. Yeah.
Okay.
But instead of telling the beneficiary what's the statement of accounting.
Okay. So that's where our rights our substantive rights as a man come in as the beneficiary to compel the production of those records. That's exactly where that is, correct?
Right, and that's only a prima facie showing, and that's easy by affidavit.
Affidavit in private.
Just set up the prima facie case. All I got to do is make the accusation.
Okay. And then they have to produce it under affidavit under penalty of perjury.
But want it to be a certified acknowledgement.
A certified acknowledgement. Okay. And the same, whether it be a court or if we were dealing with with a bank, for example, through the U.S. mail, it would be the same type of situation. If we make a prima facie case as a beneficiary, then they have a duty under trust law to produce, correct?
Okay, did we just switch gears to a bank setting now?
Yeah, well, because you gave me the idea of that they would do it it would be done in camera, would it be the same situation? My question is if we were dealing with a bank, if we were to express this grant as
Wouldn't make
beneficiary.
Because, whether it's a bank or some other entity, it's all the same kind of dealing with it. It's all under trust.
And then if they failed to do that, then we would have a action in the colorable side of the court based on the CCI, correct?
Yeah, give them the reason to save face, but not too much truth and keep the truth out of that public side.
Then the real skill would come in and put in that complaint together not to disclose too much.
Right, just, the colorable notices on the public side only.
And when you say notices, you mean, for example, a civil complaint, colorable, is that what you mean, or would it be a different type of notice?
Well, basically be the same as what we've been doing with those 3 lines or so that we talked about, the claim and the
Okay.
Transfer.
Okay, I'm right there with you. So the claim we could disclose in the public, but of course the proof would be in camera.
Yeah, the claim would be, say, the cause of action or, say, the breach of trust.
Well, when you said 3 lines, you're talking about what you would see in collateral block 4, or you mean what we put in block 4 on the UCC1? Is that what you mean?
Yeah, that notice, yeah.
Okay, just to make sure I got that right.
Another one, Eric?
Yeah, one of the things that we were, I was talking to actually a friend of Chris Summers today. She discovered something called the UNRUH Act. It's spelled UNRUH. Have you heard of that before?
How do you spell again?
UNRUH.
No, I don't believe I have.
Okay, and the woman who shared it with me is a woman by the name of Phyllis, and she's quite a hunter when it comes to digging up information. And what she learned is in the UNRUH Act, and this is something I think in the state of California, so I have a question about that, if we can utilize it here in Florida or federally. But what she discovered is that when they wrote the UNRUH Act, they put in there that on the till, on loan documents, that they have to disclose that I think the till is a security instrument. And going back and reviewing the till that I've seen in my practices and mortgages in the past, they don't disclose that on the till, and they specifically leave that information out. So I started thinking about this. Now, that obviously is a misrepresentation, but because they omitted it, would that actually constitute would that go all the way to the level of fraud?
It was especially under a statute, and they were required under the TILA that's supposed to do that, then yes.
Okay. So then my next question in utilizing, if it's possible to do utilize the UNRUH Act, and I only had a brief period of time to do some research on this. Maybe if Chris Summers comes on the line and he can comment on this, if he's talked to Phyllis since earlier this afternoon. if it is in fact only in the California statutes, is it possible for us to use statutes of other states in the federal or here in the state of Florida, or both?
Both you can. If you judicially notice them, bring them in.
And how would
state? If the state doesn't have a law, then federal would take place. So yeah, you got to bring the federal in.
Savings to suitor.
Uh-huh.
So the proper judicial notice would be a savings to suitor notice?
Well, you could
Savings to
judicially
suitor
notice the savings to suitors clause, yeah. But that's how you'd bring in any other foreign law anyway. Bring it in by judicial notice.
Where can we find a template of how to bring that in, or is somebody on the call want to share it with me, or anybody got it?
Your state evidence rules if you're in a state case, or your federal evidence rules if you're in federal.
Okay.
Christian, isn't that the full faith and credit provision that allows you to import laws from other states?
Yeah, you could claim that, but you know, if you judicially notice it, might not be so necessary to say full faith and credit. But I would judicially notice, say, if I was in a state case, the federal statutes and codes, or the federal laws, or whatever, and that the court would have to take judicial notice of the fact that they exist.
Hey, Christian, I got a question.
Yeah, Eric, are you done?
Sure, I'm sure I'll have plenty more as time goes on, but please open it up for somebody else.
Okay, go ahead. What's your name? Identify yourself.
This is Darren down in Florida.
Darren, how you doing?
Good. Did you ever get that UCC one I sent you?
I've been so busy here the last I've had a chance to even check any emails of anything.
Oh, you're telling me. I tell you, it's amazing what these courts are doing. But anyway, the question is once you do your private side in regards to your notarial protest, take it to the full extent, then you file the public notice of a private judgment via UCC1. Now, when you open the case, that's when that's when you complete the UCC3 and make it the trust res at that time.
Okay, go through that again for me, please.
I'm just is that once let's say for an example, like with me, I have a large pending suit that I'm taking into federal. Now the thing is, I have basically defaulted everybody via non-compliance on the private side, filed a UCC1, and also gave notice to certain state parties. Then the question is, when I open up the case, it turns into, that's when I do the UCC3, correct?
The 3 I used for the transfer, and if you used whatever you had on the 1, that would be what it would be transferring. So it sounds like if you want to open up a case, use the case as a res?
Yes.
Well, you'd have to open the case and then do the 1.
Oh, okay, but
you have to claim the case on a 1.
Oh, I see. Now, if I've already done a 1, but that means I could do a 3 right now, even before I open the case.
Well, no, you couldn't open a case and put it on a 1 at the same time, simultaneously. You'd have to have a 1 filed with the case open, and then after you had the 1 filed, after you opened the case, then you could turn that case into trust res property.
Okay, well, you can always amend that, and instead of redoing the whole thing all over again, you could do a correction, I think, with the UCC.
Yeah, I'd do an addition, yeah.
Right, and then, so, basically, just I'm trying to just understand, UCC is new to me, just like the trust stuff. Been working on just statutory stuff for so long. Is that the UCC1 that's currently, it's already defaulted on the private side. Now, but the 3 doesn't really come into play, actually, until a case is open. Isn't that correct? I was under the impression that's what we talked about before.
Well, if you wanted to use the case as a trust res property, you'd have to have the case open so you knew what the number was, so you could claim it on a 1 first. Then once you claimed it on a 1, then you could do the 3 transfer.
Okay, but it still doesn't hurt even doing a 1 even before the case is not open, so this way it's just a public notice of a private judgment, correct?
All right, so yeah, you could make that in addition to the case. Once you open the case, then make an amendment and then put an addition onto it.
Okay, that was my only question. And
You always first claim the trust res property first on a 1.
and that's basically the private judgment. That's the property, correct?
Yeah, you could use the private judgment as your trust res, or you could do a separate filing on a UCC1 and claim the case separately too.
Or how about this? What if you open up a case after having a UCC1 and then use a UCC3 for an assignment to the open case?
Now you have to claim it first
Before you
claim
can
it on a
transfer
1 or a mid 1, so that you got the right to transfer it on a 3.
Is that Chris Summers in the back?
Yeah.
Chris, this is Darren. Hey, empty your phone. I tried to call you this weekend, and it said the whole thing's full.
It's not even supposed to be on.
Well, you're a tough person to reach. I just tried to touch base with you. It's like sending Christian an email. It bounces back.
That should only be with the moving titles or the Hushmail account. The other ones.
I sent him in a boat just to cover my bases, but I'm hoping here soon. I'm up north right now, but I'm going to be back in Florida. I was hoping maybe I can meet up with you, Christian. I don't know if you have any time.
I got time, but I make time, I guess.
Okay, all right. I'll touch base with you, and Chris, give me a call when you get a chance, because I only have your one number.
Yeah, okay, I will.
All right, guys, thanks.
Anybody else have a question? Press *6 and state your name, where you're from.
I had a question.
Yes, who's this?
That's Jacob in California.
Jacob, how are you?
Oh, I'm okay. How about yourself?
Oh, all right. Getting some feedback on the ground here.
I'm talking on a telephone and there's a speakerphone. Is it better if I talk like that?
Yeah, it's a little better. Yeah, you don't get the background echo.
Well, that's the best I can do. I had a question about a quitclaim deed. How to use it as expressing the trust.
Mm-hmm.
Have you worked on that at all?
Claim deed. How are you thinking of using it?
Well, there was a foreclosure, and so what I did is I converted the quitclaim deed into an expressing the trust. So I went back and stripped the form of any statute and code language, and then used trust term language to express the a passing of the title from the original grantor to a trustee, and I invented a new kind of trust called the home trust. And so the title passes from the original grantor to its lineage and family in the home trust, and one of the siblings becomes the trustee, and then the grantors, the parents, express that they are the grantors of the trust and that they're transferring title to the home trust, and the child is becoming the trustee in that way.
Trustee? Who's becoming the trustee?
The son. In this case, he was the oldest son.
How old is the son?
40.
Oh, okay. I was thinking maybe if it was a younger under 21, he can't be trustee.
Right. So, as an example, the
Okay, is this in a mortgage foreclosure case or anything?
yeah. And so what I did is I stripped all the language out and filled in other language, and so then I put, like, for valuable consideration, I put the receipt of which is hereby acknowledged. And I didn't know if I should put for valuable consideration, if I should express that the trust was the valuable consideration.
Yeah, I think you're going about it all wrong. If this is a mortgage foreclosure, you want to use the case itself as the trust res instead of the property.
Well, it's in an unjudicial state.
Okay, so it makes no difference. You still have to use open up a case and make that case then your trust res property, incorporate everything into it. So you'll have to come at them with an independent action and come in basically with say your counterclaim. Treat that case as the trust res, incorporating the house, the property, and everything in it, and all the proceeds and everything from it.
Mm-hmm.
See, what you're trying to do is you're trying to use the quick claim deed to hide the asset, and that ain't going to fly, I don't think. We're not really trying to create a trust that way. You know, I would go out with an independent action, coming in with the counterclaims, and using that case as the trust res. And I might do like a 9-210 under UCC, what was A4, where you're doing the debt validation, basically for validation of the account. And when they don't do that in 15 days under the UCC, certify the dishonor of the notary, and that would give you the unclean hands doctrine, which you could use that as an estoppel and come in with a preliminary injunction or maybe a temporary restraining order to stop the sale.
What UCC was that again, Christian?
9-210A4.
Say it again.
9-210A4. So when I make up my documents, I'm going to tell them under UCC 9-210A4, I'm going to specify the amount as being zero owed, and if they don't come up with the rebuttal to that in 14 days, then that's going to stand that I owe zero.
Christian, would that same thing apply to institutional funds and also private funds?
Yeah, should. Yeah. Now, I don't need to put in the UCC coding in there, but I'm going to use the intent of the code and use that.
Mm-hmm.
Okay. The important thing is that once you get the notary to certify the dishonor, that dishonor is the powerful thing. That's the thing that's going to create the res judicata estoppel.
Okay.
That's where in a court of equity, where trusts operate, equity is going to say you can't come in and do a foreclosure, whoever's doing the foreclosure, and ask equity to claim the foreclose on the property for you when you yourself do not have clean hands. Because the dishonor by the notary is going to certify the unclean hands doctrine. Now whoever is bringing the charge against you is a stop. And we really didn't understand the power that we really had under the unclean hands doctrine. That gives you the ability to come in with a temporary restraining order at least, or a preliminary injunction, and stopping the foreclosure even in a non-judicial state. But you got to come in with an independent action, use that dishonor certified by the notary as your unclean hands certification.
Okay.
Now whoever is trying to foreclose on you, they're stopped. Period. You can get that case thrown right out.
When will you post this tape recorder thing?
It so happens that tonight I'm not really recording because I don't have the capacity to record it.
Uh-oh. Chris,
I'm recording it.
Are you recording?
Yeah.
Okay.
We've talked about this before in the past, and some great in-depth on some of the other past shows. I don't know exactly which ones they are, though.
Can you approximate date?
Shoot, I know that I'm pretty sure it was a Saturday show, so you might want to check some of the Saturday shows.
How many back? Month?
I don't know exactly which ones.
Does anybody else remember?
Hey, Chris, which email do you use? Which is your mostly used email address?
Well, I'm switching everything over to the movingtitles.com email addresses. So if you send me...
No, I mean Chris Sommers, if he's recording it. He's like you, he's got like 3 or 4.
Oh, yeah. Well, why don't you just Skype me, Handy Summers, and...
what is it? What is your Skype?
Handy Summers, that's Handy Summers. And when I accept you as a new person on Skype, resend a hello and ask for it, because for some reason it becomes evasive after I accept you, and I don't know who sent the acceptance to become a Skype member. Funny little thing that happened.
Sounds like my ex-girlfriends. Once they accept me, then they get evasive too.
Hey, Christian.
Yeah. Who's this?
Hi, Christian. How you doing? My name is Dominic. I'm calling from Ireland.
Hi, Dominic. Hey.
How you doing? You doing good?
Right. Yeah. Was the other fellow down there in the quit claim?
That was Jacob.
Jacob, okay, yeah, couldn't remember his name there. On the 9-210A4, that was the request regarding, but I don't use request. I use the demand regarding a statement of account needs a record authenticated by a debtor requesting that the receipt approve the recipient approve or correct. So approve. So I'm using an approve my zero balance. So approve or correct a statement indicating what the debtor believes to be the aggregate amount of unpaid obligations secured by collateral as of a specified date, and reasonably identifying the transaction or relationship that is the subject of the request. So I'm basically going to say also it could be that it's paid and it's a zero balance. And what is the transaction or the relationship? The relationship? That's a trust. I'm going to put in there that's a trust relationship under a special deposit, and that's how it got paid. Now, I might want to keep the facts out of that a little bit, but if I ever got into court, I could come into court with that. But then once that dishonor is achieved by that, or I put in there that they approved the account within the 14 days because they didn't respond, they approved my zero balance because my transaction was paid and my relationship was really a trust. Yeah, then it comes in under the 9-625 under comment 6 is there's the estoppel and there's the temporary restraining order.
Which one was that again?
9-5.
265, did you say?
625. 9625.
Well, wait a minute. You said 225 before.
Yeah, I was talking about 9-210A4, and then now 9-625 comes where the estoppel is under the official comments number 6.
Okay.
So 625 is, let me get to that one. This is non-compliance with this whole article, and that's where the 625 is remedies for secured parties' failure to comply with this article. In other words, that section in there, Article 9, they failed to validate the debt under the 9-210. So the 9-625 remedy takes an effect for their failure to comply there. Those section, but then under number 6 it says estoppel under subsection G. And what is subsection G here? Let's see if I can find it real quick. it's the limitation of security interest or noncompliance with Section 9-210. So if the secured party fails to comply with a request regarding a list of collateral or a statement of account, now that's what we did, statement of account under Section 9-210, the secured party may claim a security interest only as shown in the list or the statement included in the request as against a person that is reasonably misled by the failure. Now that brings in misrepresentation, and you want to take and come under the 3-202, which is illegality. There's another cause of action. Misrepresentation. Now we've got fraud coming in here. Now back to the number 6 official comment under the estoppel, subsection G, which we just read, limits the extent to which a secured party who fails to comply with a request regarding a list of collateral or the statement of account may claim a security interest. Now stop his claim to the secured party to enforce. Now you can also bring in under the 9625, the number 5 official comment, which is the supplemental damages. That's the value of the property that you're claiming, or whatever it is. Then under A, 9-625A, judicial orders, and there is your injunctive relief or your temporary restraining order. So it says if it is established that the secured party is not proceeding in accordance with this article, a court may order or restrain collection, enforcement, or disposition of collateral on appropriate
What number was that?
conditions.
I'm sorry, what number was that?
This is under the 9-625, under A, under judicial orders concerning the non-compliance. That section A is where your injunctive relief or your temporary restraining order, preliminary injunction comes in. So that's from the breach of the peace, say, or excuse me, that was another case I had there, breach of the peace. Next is section B, which is damages for the non-compliance. So it says that section C, D, and F, and a person is liable for damages in the amount of any loss caused by a failure to comply with this article. And the loss caused by a failure to comply may include loss resulting from the debtor's inability to obtain or increase costs of alternative financing. That could be due to, say, bad credit reporting. Now you got a bad credit rating and you can't get financing. Would that damage be worse to you?
Christian?
Yeah.
Here's another one that ties right into this 9625A. That is the title USC 12 at 93, a forfeiture or franchise. It's almost identical in some of the language you're using here in 625.
Okay.
And it also assigns liability to the opposing party that has failed to comply.
Yeah, Title 12, you say?
Yeah, Title 12 at 93.
That'd be banking, then. Title 12 banking.
Yeah, it's they call it forfeiture or franchise.
I mean, it's like, okay, you sin on one thing and you end up sinning on all the commandments. You know, you break one rule, you broke them all. You know, it's just a matter of connecting them ones all together, because you can dig up more all the time. Then you have the supplemental damages under E, under statutory damages, where the non-compliance. So in addition to any damages recoverable under Section B, the debtor, consumer, obligor, or person named as a debtor in a filed record as applicable may recover $500 in each use case from the person that, one, fails to comply with Section 9-208, 209, and The other one, under 4 there, it says fails to cause the secured party of record to file or send a termination statement under 9-513A or C. Then you could come in with the supplemental damages under F, under statutory damages under section 9-210, where it says the debtor or consumer obligated to recover damages under section B, and in addition $500 to each cause or case from that person that without reasonable cause fails to comply with the request under the 9-210. But I mean, it's the $500 doesn't seem like much, but trouble is, it's not the $500, it's the other stuff that comes in with. How do you put a value on your bad credit? And then it's also the amount of whatever it is that you're claiming, whatever its value is, it's that plus this other. So really the $500 is not much, but it's the other stuff that is. How do you put a value on the bad credit report? What's that worth to you? And then the misleading on the failure to misrepresentation under G there, so that same 9-625. So then that brings in then 3-202, the illegality. -202. So that's 3-202, that's negotiation subject to rescission. Under A, it says negotiation is effective even if obtained 1 from an infant, a corporation exceeding its powers, or a person without capacity, and 2 by fraud, duress or mistake, or 3 in breach of duty. Breach of duty, was that breach of fiduciary duty, breach of trust, or as a part of an illegal transaction. So that comes back in, illegal transaction. That's bad faith. And bad faith could be 3-308, which is proof of status as the holder in due course.
What was that 308?
This is all debtor creditor stuff, but you could use this on the colorable side of the court, just under debtor creditor side.
Was that 3-308?
Yes, 3-308, proof of status.
That's proof of status.
I would claim that the instrument was the stolen instrument that they were trying to foreclose on me with. And it was an illegal transaction. And it gives me a right of rescission. So under B, to the extent permitted by other law, negotiation may be rescinded or may be subject to other remedies, like under 9-625. But those remedies may not be asserted against a subsequent holder in due course or a person paying the instrument in good faith. So is this good faith, though, really? And without knowledge of facts that are a basis for rescission or other remedy. And it goes on and on and on and on, really. Bring this stuff all together all night.
Christian, I've got a question for you.
Yeah, go ahead, Chris.
The UCC, as its own set of laws, does that mostly pertain to trust, or does it pertain to commercial transactions, or does it include both? I'm trying to understand where everything's positioned here with the UCC.
Well, UCC is really debtor-creditor, but I'm starting to see it with more of a trust eyes than what I used to see it as.
Mm-hmm.
I mean, if you look at 4-103, where is it? Let's see. Sure. 4A. 4A. 4A is really funds. 4A is funds transfer, and 4A 103 is
By agreement.
A. You know, it's talking about beneficiaries. Isn't beneficiaries a trust term?
Yeah.
Well, I'm starting to see, say, funds transferred, instead of it being under debtor creditor, it's really could be trust funds transfers under trust.
So in other words, what you're saying is that the guideposts to most trusts are not in equity, but they're in trust, but they kind of follow in suit to the whole standards?
Well, what I'm saying is that the trust we're talking about here is really a statutory trust, which is really, trust is operating this debtor-creditor stuff under UCC, but it's a statutory trust.
Yeah, okay.
I mean, why else would they have under 4A talking about beneficiary banks and beneficiary terms and all this other stuff? Beneficiary, that's all trust. No, and I didn't pay too much particular attention to that before, but now it kind of hit me and said, well, my gosh, this whole section, funds transfer, that's really not transfer under debtor creditor, that's really trust fund transfers.
Right. Yeah.
Okay, well, that's all I wanted to say. Any other comments on that? Otherwise, we'll go to Dominic then. Dominic, you still there?
Yeah, how you doing, Christian?
Okay, go ahead. Why don't you go ahead?
Okay, thank you. So I didn't mean to cut across Isaac earlier. I thought he was done. I just have some questions here, Christian, and some of them might be elementary enough, but I'm just there's a few of us over here, obviously, decided upon that are asking. We just want to know some more information. My first question to you is regarding a mortgage. Can you hear me?
Yes, I can hear. Yeah, if anybody else isn't talking, why don't you please mute out? *6, yeah. Okay, go ahead, Dominic.
Okay, thanks, Christian. Regarding, we'll say if I was to request a redemption statement from my mortgage company, and they send it to me by post or whatever, this is a clear debt title, isn't it?
Yeah, it is a certificate, yeah. A redemption, or whatever you want to call it, right of redemption. So what are we basically asking them for? What, like the total amount to buy it out?
Correct, yes.
How long would they have it before, after, say, a foreclosure? Is that right?
Well, I think normally they give you is 21 days, as far as I know, to clear it.
Mm-hmm.
So I was just wondering, we were just thinking over here, if we possibly went ahead and requested them, when we returned them as an asset title by claiming and expressing and moving it, that zeroes the obligation and terminates the trust, doesn't it?
Yeah, under Section 159, yeah, the merging of the title that actually is the payment.
Okay. Now, what's the situation with the original promissory note we signed? Because that's obviously still being traded in the background. Is this now cancelled as a result of us doing this on the redemption statement?
The note should have paid the mortgage at closing, but since it didn't, doesn't mean that it still doesn't exist and it's not able to. In fact, that would be the payment, yeah.
All right,
and
okay,
what else drawn against it and generated from that, you know, all that stuff is mine also, or yours.
Okay, so would you still go after that, express it as a special deposit, and go after it?
Yeah, how long has it been?
Well, I suppose in my case it's been 5 years.
Oh, and then it might be worth going after because, you know, all that stuff's been running in the background, collecting interest, and that's all yours.
Okay. And any other associated trust like deeds and escrow or whatever, also the same as well. They'd also still be active enough, like even though I did offset
yeah.
or yeah.
still held in special deposits, still held in trust deposit.
Okay, that sounds very good. I'll just move on to my second question. If a mortgage is fully paid off, I've had a couple of previous mortgages fully paid off. No, I could still obviously go after the original PN as a special deposit. I presume I would still require a dishonor before I could actually move in, couldn't I?
On some of the mortgages that have been paid, you say?
Correct, yes.
And you want to get a dishonor first, you say, in order to act on it?
Yes.
What would you use as a dishonor?
Well, the only thing I can think of, Christian, is if I just requested the note back, seen as the actual
demand for the note,
or demand for the note back, and any other we'll say associated allonges or any associated information regarding insurances, etc. I could ask for that information back. I could do that under debtor creditor, could I?
Instead of a demand, I would do it this way. I would order the note back. Do an order the note back under trust.
Order the note back under trust. Okay.
To them, surrender the note.
Now, I was saying to you last week that obviously what they do here, and
say that again.
Sorry, Christian. I was saying to you last week that here, pretty much, it's kind of black and white that they do commingle funds and that they do sell securities and mortgages, etc. So it's highly doubtful that I will get the note back. So in that case, if they say they've lost it or whatever they've said, what is my comeback?
They commingle, then just give me the money for it then.
Okay, cool. And how would you if you did get them into dishonor, what process would you use? Would you still send off an indenture, express the trust, claim the trust, etc.? Would you still do all the same procedure?
Yeah, if I was going to move forward on them, I'd have to, claim the trust and prove the trust.
Okay. You know the way... A second, I just moved on here. I have some questions here. Do you know the way when lenders are construing you under debtor creditor, but they're actually coming from trust?
Right.
When we ask for documentation, we're asking it under the construment of debtor creditor. But if they're actually genuinely under trust, are they obliged to release documentation if they are in fact actually operating under trust? And if we do get them into dishonor, is it actually a dishonor? Because it's not actually debtor creditor, it's actually trust, but they're construing it as debtor creditor.
Yeah, I would think you'd have to get your trust standing established first, and then once you got the standing of the trust, then you got the right to make the claim and order the accountings. And but here, all this time you've created the evidence that it's really debtor creditor. They didn't really create the evidence, you did, because you put your signatures on all this debtor creditor stuff. But now you got to create some counter records under trust that it wasn't a trust, and then do the debt validation, giving you the right of rescission under that 3-202 under the UCC. And when I mention the UCC terms, I don't put UCC stuff in the exact quote of the UCC statute code. Just use the intent.
Just use the intent. So we can still proceed obviously under debtor creditor. It's still considered to be a dishonor, correct?
Yeah, and then get that dishonor certified by, say, a notary or some way that you can establish the fact that there was a dishonor.
Okay, fantastic. Because we were just wondering about was it actually a dishonor? But you're saying that since we signed it under debtor creditor, and since we can establish a dishonor and get somebody to certify it or notarize it, it's basically an established dishonor, and they have unclean hands in equity.
Right, which I could use on the colorable side of a court case on an action against them. where I bring in the causes of action, say for the breach of trust, commingling, and anything else.
Okay. Now, in a court situation, Christian, if somebody disclaimed the appointment of trustee, the court would not let the trust fail, and therefore would appoint a trustee. This is fairly obvious from Gilbert's and what you've been saying recently. Now, what about an out-of-court situation where trying to merge the titles into one individual? If we say we...
Might depend on where you take it. You probably won't get some kind of result until you take it into a DIB hearing of some kind. That DIB hearing could be state treasury or maybe another court case.
Okay. Because we've been talking here and we've been kind of figuring out, all the CFO or whoever that we've appointed as trustee has to do is pretty much just refuse the trusteeship, and then obviously it's going to be necessary to involve the court or schedule an equity hearing and
get it into equity. Yeah.
Sorry?
Get it into equity into a court, and then let the court handle it from there.
Okay. And obviously, if they return our paperwork and say, we don't recognize this as a valid trust, we refuse your paperwork, etc. The same would apply again. Obviously, then you would obviously initiate a hearing in equity.
Still for a valid trust?
Yeah.
Well, how could they refuse a valid trust?
Yeah, that's true. If you've met the legal fulfillments of the trust, they can't really invalidate it, can they?
No, I don't think so. I don't think so. Now, if you got a valid trust, the only way they could maybe not do it is maybe you didn't present your trust the right way and prove it. Did you have all the necessary elements? Did you have the method of formation? Did you have the records that you could prove the trust? Now, then I could say maybe they might refuse you for that because you missed something. But if you had a valid trust, I don't see how they could not allow you to go ahead with what you said.
Okay. Now, you mentioned something there about proving the trust. When you say prove the trust, obviously you're doing an NOI and an SOI. But when you're sending off documentation to them, Christian, would you send off a certified copy of the original agreement with your signature on it?
No, if I was going to cause of action in a court, I would come in with copies, but I would have the originals handy so that in case I had to prove it with the originals, but I would come in with, say, the copies first.
Okay, but when you sign, we'll say for a mortgage or a loan or something like that, and they obviously keep the original and they sell it. Did you not say before that it would be wise to get a certified copy of that document, or even a copy of that document, so you could prove that your signature was in fact the only signature on the document, and it would be proof of trust if you expressed it correctly?
Yeah, certified copy especially.
Okay.
If not, I can't get a certified copy if I at least have some kind of copy.
Yeah. Now, obviously, because they've sold them...
Signature, and it was my intent and purpose that that's a trust formation. By the way, here's the record of proof that there was a trust res transfer. I got a trust.
Yeah. Now, failing the fact that they would be able to issue you with a true certified copy from the original, because the original is no longer in existence, you could always get a copy from the lender and perhaps ask them to stamp it, and I think that would do also, wouldn't it?
Well, is there any public filing of any of the documentation, say? There almost have to be someplace. Just go get a certified copy from the record keeper. Public record keeper.
Okay.
Don't you have like a county recorder that records all your mortgages and your notes and things?
You see, we don't have county recorders here. I'm just, I don't know where they'd be. I know we have land registry here, where we have registration of all our title deeds, etc.
So how do they enforce a foreclosure then? What's their how do they prove liability? Where's the security agreements and the contracts that how can they come forward with just copies?
Yeah, I'm not too sure. I'm not in that situation myself, so I don't actually know how they would actually enforce it here. Obviously they just use the courts, and I've been told here that copies are pretty powerful enough in this country. So, but I'm not actually too sure the actual.
The signatures on there are frauds, and the instruments are stolen. Now they got to come up with the originals.
Yeah. Now
look at 3-308, the proof of the status, because once that 3-308 in UCC, 3-308. That's the proof of signatures and status as holder in due course. Now, I'm going to pull it down into the official comments, section 1. It talks about that second line in. It says, the purpose of the requirement of a specific denial in the pleading is to give the plaintiff notice of defendant's claim of forgery or a lack of authority as to the particular signature, and to afford the plaintiff an opportunity to investigate and obtain evidence. So if the local rules of the pleading permit, the denial may give information of belief, or it may be a denial of knowledge or information sufficient to form a belief. It need not be under oath unless the local statutes or the rules require verification. But in the absence of such a specific denial, the signature stands admitted. And that's probably the same situation you guys are going through over there. You're not saying, I deny specifically the signature. Once you deny the signature, otherwise, if you don't deny the signature, they can come in and foreclose on copies. Let me see where that's at in here. It specifies that in also. Well, let me read on. I'll go on. In the absence of such a specific denial, the signature stands admitted and is not the issue. Nothing in this section is intended, however, to prevent amendment of the pleading for a proper case. So the question of the burden of establishing the signature arises only when it has been put in issue by specific denial. The burden of establishing is defined under section 1-201. The burden is on the party claiming under the signature, but the signature is presumed to be authentic and authorized except as stated in the second sentence of subsection A. And presumed is defined in sections 1-201 and means that until some evidence is introduced that would support a finding that the signature is forged or unauthorized, and that could be nothing more than just an affidavit setting up a prima facie evidence. So some evidence introduced that would support a finding that the signature is forged or unauthorized, the plaintiff is not required to prove that it is valid. Let me repeat that again. The plaintiff is not required to prove that it is valid. The presumption rests upon the fact that in ordinary experience, forged or unauthorized signatures are very uncommon, and normally any evidence is within the control of or more accessible to the defendant. The defendant is therefore required to make some sufficient showing of the grounds for the denial before the plaintiff is required to introduce evidence.
Is that under 308? 3-308?
Yes, the official comments. That's why I keep telling everybody you gotta read the official comments. Get the UCC with official comments.
Oh, okay. Because I'm reading. I'm going. Wait a minute. This just has A and B online.
No, the official comments. So the defendant's evidence need not be sufficient to sufficient to require a direct verdict, but it must be enough to support the denial by permitting a finding in the defendant's favor. Until introduction of such evidence, the presumption requires a finding for the plaintiff. So you got to bring in a denial and some kind of affidavit specifically denying it.
But you don't have to show anything more than just the affidavit, really. You could just say, and I know a gentleman that does this. He calls it.
prima facie case is nothing more than an affidavit which points to a competent fact witness to be put on the stand and can testify that's not my signature.
Right, and because the only way they can do it, they have to do a rebuttal affidavit within 20 days on a point-to-point basis.
But other than that, they got to come up with the original. How else are they going to prove that it hasn't been stolen? Because I'm going to state that it's not my signature and that's a stolen instrument.
You know, it's funny, Christian. I just did a writ of habeas corpus on a girl. They're trying to steal her house through one of these foreclosure mills in Florida, the Florida Default Group. And I said, is that on the note? You should see this. And the judge just went ahead and allowed them to re-motion for the sale. And I put in there for her is that she denies that those are not her abbreviations. That's not her signature. Just deny. This way they have to come up with the original.
What kind of discovery did she do?
Oh, they have provided nothing. She did a petition for discovery. She filed a petition to compel discovery. She filed interrogatories, and they've answered nothing.
Did she do a show cause hearing for them to be put up in contempt?
No, because the judge didn't even sign the order of compelling yet. Even the judge is just, it's just unbelievable, especially what they're doing. Well, it's Florida. You know Florida.
They didn't sign the order to compel?
No, they didn't. So what she's doing on the writ habeas, we filed another order in there to sign it for that. She also did a letter to the chief judge, because
summary judgment cannot be granted if you still have discovery in place, and if you're proceeding along with the discovery, then, and if you've denied these signatures, they got to produce the originals. I know, but I'm just saying what this judge did. I mean, here's a key factor, though. You got to do it in the original answer.
Yeah, it wasn't done in the original answer. No.
That's what killed her.
But she still has But she still has appealable grounds for it.
Well, it could be denied because she didn't make a specific denial timely.
Right, but I'm just saying she can go to appeal and bring up the issues in controversy.
Yeah.
And then also file for a TRO so they don't foreclose on her house. But you see, the problem is she had somebody else doing it, and this guy totally dropped the ball. He even filed a notice of appeal to the appellate court, and then he never wrote the brief for her. So, of course, they dismissed it. So that shows the lower court is basically made their ruling. She can't go to the appellate court because they already dismissed it because they didn't file an appeal. But yet again, too, she might even get a better remedy in federal court.
Well, treated to come at them as under trust.
Right. Okay, all right. Hey, where do we find what you have, the special comments? Is that did you get that book somewhere specifically?
Well, it's just the Uniform Commercial Code, the official text and comments from Thompson West.
Oh, okay, because I'm just...
Check around your law libraries, including the state law libraries. Generally speaking, they have an area within those state law libraries that they sell their used books that are a year old or more.
Right.
And you can pick for like $3 to $5 a piece.
Well, the only thing, I'm up north right now, and I'm in a town that doesn't even have a Starbucks. I'm hurting.
So, Christian, I'm just a tiny bit confused on that signature point. Are you saying that we would have to basically that they would have to produce the originals in order to enforce a foreclosure? That we could just say that these are forgeries on the document, or what?
In this country, once we establish the fact that we're specifically denying the signature and making a claim that they're stolen instruments, they're forgeries, then it's up to the plaintiff now to come up. The burden of proof shifts to the plaintiff, and they must produce the originals.
Okay, all right, I gotcha. Because on one hand, a copy of it is proof to you that you're the only signature on it. Now, obviously, a bank witnesses your signature too, but isn't that proof that you are in fact the grantor? So you can't really use it as proof.
3-5, yeah.
But you can't really use it as proof of grantor if in fact you're denying the that it is in fact your signature on it.
Correct.
Because it's not the original.
Right. So you're going to have to decide which way you want to go.
All right, I got you. But you don't need a certified copy to prove trust anyway. You don't. No, you don't. No.
No, I just need the grantor to testify that that was his signature. I mean, that's the only one that's going to be able to testify. He's the one that's going to authenticate it.
Yeah. Okay, so you just need to decide which way to go and which way to construct your attack. Like
you're doing under 3-308, the plaintiffs are coming in with copies and foreclosing on copies because people then specifically deny that they weren't. Now, the only one who can establish that they're not originals under this case would be the grantor himself because he made the document out. So if the grantor says that he made the document out, that's my signature, that's my document, then who else is going to say anything otherwise?
Okay. And then they can come in and they can possibly, if you admit it is your signature, obviously they can enforce it under the strength of that. But then again, you've got to trust.
Yeah, you need the proof that it is a trust, that the records got all the elements there, and that you got a record of a transfer of res property.
Okay.
To the trust.
I got you.
Now you got a trust.
Okay. Which is far more powerful, obviously, than what they're trying to do. Plus, you're operating in equity as well.
Yeah, that's why the U.S. versus SNAP came at SNAP under, instead of two signed contracts, and the U.S. was the CIA, under an employment contract. They didn't come at him with breach of contracts for employment. They came at him under trust.
Yeah.
That's always the big
trust.
question. Why did the CIA come at SNAP when they had two signed breach of contracts under employment? Why did they come after him under trust?
Yeah. That's interesting.
Totally different that they didn't even have any kind of, which points out the fact that no one needs to know that a trust was being formed. So here was SNAP, didn't even know a trust was being formed, but yet the CIA enforced it to being a trust and ended up winning it. Took it all the way up to the Supreme Court, ended up upholding it.
Christian, just a couple of more tidy bits, and I'll leave someone else come on the call. But when you say, I'm just clarifying this, when you say claim title, the title you're actually referring to is the asset title, correct?
The what kind of title again?
Asset.
The asset title. Yeah, the res property. Not so much the asset title, but the res, the thing. Because asset does not have to have. I kind of think as an asset it has to have value, where trust doesn't have to have value. It's just a thing.
It's just a thing. So when somebody sends you an offer, it actually is effectively a debt title. So are we converting it into an asset title, or are we just creating a new sort of title?
I would say it would be the antithesis of the debt title, which would be the title to the asset, which would be a corresponding value, if we want to go by value, or the corresponding res. Let's put it that way.
Okay, so we're not converting, so per se.
No, it's just taking a piece of paper that says you owe, and I'm giving another piece of paper saying it's paid.
Okay. Okay. And in our sorry, Christian. In our paperwork as well, Christian. When we're submitting our paperwork, we're obviously submitting receipt receipt of an NOI, an SOI, along with an affidavit of obligation, an indenture, certificate of dishonour, true bill, or whatever we're sending. But that we would send a copy of an NOI, SOI, and an affidavit of obligation as well. Correct? I know. It depends on the circumstances, but does that sound okay?
An NOI supported with an SOI for proving trust. Is that what you mean?
Yes. Yeah.
Yeah. An NOI always treated by some kind of proof. Proof is the material fact or the SOI.
Fantastic.
Can't make
No.
an unsubstantiated claim just with an NOI itself. That's an unsubstantiated claim without an SOI.
In the case of an indenture, a trustee, an appointed trustee, does not have to sign the indenture. Obviously, he doesn't.
No, it's only the grantor. It doesn't have to be signed at all. It's really the intent and purpose of the grantor.
Okay. Okay.
And
But I think the main question on this side of the pond is yeah, you know, we can get our paperwork right, we can send it off, but at the end of the day, this guy can basically say, you know what, I refuse it. So then basically we need to learn how to schedule a hearing in a local equity court and have them decide it. Would you go along the lines of an injunction also?
Well, an injunction is an equitable relief which is going to compel whoever it was from stopping them from breaching.
Okay. Fantastic. Christian, I'm done. Thank you very much for your time. I'll let someone else take over the call now. Thank you so much.
Okay, Dominic. Appreciate it.
Thank you. Bye.
Christian?
Yes, Christian.
I heard three voices there. Who was first?
I was just going to try to ask a question to finish up the answer that you were giving before Patrick came in. And that was the one about the quitclaim, but he ended his conversation on this affidavit of obligation, and you had started the quitclaim about the debt validation. And I was wondering that under creditor-debtor, those type of documents, most of them are kind of statute code oriented. So how do you convert debt validation and an affidavit of obligation into trust language?
Okay, I'm just using the dishonor on the fact that I asked him for whatever I asked him for. It just happened to be debt validation. And the notary is going to be the certificate that I'm going to use that as the unclean hands doctrine, which I'm going to bring it in under equity. That unclean hands doctrine can't, somebody can't ask equity to do what equity requires them to be doing themselves. In other words, they're operating in bad faith with unclean hands. Does that answer your question?
That's very insightful, thank you. But I guess like when you in a mortgage situation, when you're asking the so-called lender, you know, to validate the debt, the typical debtor-creditor debt validations are these super long and groovy instrument, you know, and it seems like it could do it in a much more simpler way under the trust in trust language.
Well, yeah, you could. You could come in and say, okay, first I'd have to prove trust, and that I got a trust, and then when I got a proof of the trust, then I would have to have some kind of record that I asked for a statement of accounting from the trustee. He didn't present it. He would be in breach of trustee duty, fiduciary duty right there. Have that certified by the notary. So does that make it a little clearer under trust there?
Sorry?
Make it a little more clear under a trust?
Yeah. Mm-hmm. So that statement of accounting is basically the same thing as the debt validation.
Right, really. Yeah.
It could just be more simple type.
Because in the Gilbert's book, I don't know, it's in one of the forward sections from where we were starting, but in the trust administration section that we just started, one of the trustee's duty is to, whenever the beneficiary asks for a statement of accounting, then he's supposed to give him a statement of accounting when he asks. Now, codes under statutory trust, I think it's at least once or so, twice a year, depending on probate rules and stuff and local rules and things. But yeah, basically, the trustee's got to perform according to a statement when it's requested from the beneficiary. Otherwise, it'd be a breach of trust, breach of trustee duty.
Christian, wouldn't a breach of trust also include them accruing public debt of where they've been told through regulations that they're not supposed to accrue or create public debt?
Yeah, but really, if we don't have any money, is it really debt?
Well, when they make you an involuntary servitude, certainly they're robbing you of your precious, workforce energy. That's their private property.
Yeah, they're getting you to trade your laborers for worthless nothings.
That's right. So wouldn't that be a breach of trust? I mean, if everything's under the Bankruptcy Act and everything's supposed to work in good faith, that's a breach of trust. At least that's the way I read it. It's a breach of trust that they are tricking you into forfeiting your labor, your life force, in lieu of their fraud.
Yeah. You're trying to make a connection with
breach of
my
trust.
labor being held in trust, and that would be a breach if you were commingling that. I think we'll find out that they've really been holding all our signatures in trusts and trying to balance it out, so to speak, with the bonds that they're floating against that asset that's being held in trust, or that res thing. But, yeah, you could probably make a case for that. Breach of trust. Got some background noise here. If you're not speaking, press *6. Mute yourself out.
Yes, Christian?
Yeah, Chris, are you done there with that? I guess so.
Hello?
Yeah, go ahead.
Yeah, hi, this is Bill from New Jersey. How you doing?
All right.
Two quick questions, and the first one's maybe kind of basic, but when we deal with cards and trying to get them off our backs, the question that came up the other day for me was, is the credit card situation a collateral, a secured collateral? And what does a credit look like? And where do they keep them? Who has control? Who makes these credits?
Well, I think you make the credit. They may be controlling it because you don't. You can control it, but you just don't. You abandon it.
So how do they access the credit? Do I give them permission?
Yeah, you do by falling into a dishonor under debtor creditor. Yeah.
No, from the beginning. I mean, when I sign the agreement, does that initiate their
Well, under trust, you don't have to sign anything, and in fact, you didn't even have to know. That's the amazing part.
That's
you
true.
didn't have to know that a trust was being formed, being operated, and you fell under a debtor creditor thing because really, basically, you didn't know or understand that it was all about trust.
So then in 9-2110, 4A, when it talks about secured parties in respect to credit cards, who is the secured party?
Well, under the debtor creditor, the secured party would probably be the banks or the credit card issuer.
Right, so what is their security? That's what I'm asking.
Okay, under credit cards, there really is no security. So it's an unsecured loan. But say,
Right.
hey, under a mortgage situation, it would be different.
Under what situation?
Mortgage situation where you got a collateral held up as, for the obligation.
Right, so if that's the case, do credit cards fit under 9-212?
Well, let's put it this way. Do they come under trust?
Yeah, I think it does.
So put it back under trust and get out of this debtor creditor stuff.
Right, so in that case, perhaps 9-210 wouldn't be useful in a credit card situation, asking them to show the statement of account.
Well, why wouldn't they show you a statement of account when you wanted a statement of account? I mean, it doesn't have to operate under 9-210. I mean, if you ask them for debt validation and they don't validate the debt, then what obligation have I got, what liability I got with you?
Exactly, but it said, but it's by secured party. I thought we just established that there is no security with the credit cards, so it's unsecured. So if it's unsecured, then it doesn't fit into 9-210.
Well, either way, if it doesn't, the debt validation would still be the way to go.
Yeah.
All I'm looking for is dishonor, that I could come in under equity and use the dishonor as the equitable defense and get it a stop of.
So we're using this as a ploy then to bring them out.
Yeah, to get the unclean hands doctrine, which is in equity going to make a big difference, because it doesn't make any difference how you certify that they got unclean hands. Once you got that certification in a court of equity, equity is going to require them to have clean hands in order to ask equity to foreclose on somebody.
Right, and so from what you're saying and your experience, they're not going to respond, and that would
They won't respond. I've never seen anybody who would.
Right. Okay, that's cool. And the next thing is, I was listening to one of the Monday night calls, and you said that people like myself could ask to work with one of the people on the calls as part of their 12. Is that correct?
Right. Mm-hmm.
I make a request to work with Harold if that's possible. I think he's in New York and I'm in New Jersey.
Okay, well, I'll run it by him and see what he says. Yeah.
Okay, thank you. That's it. Thank you very much.
All right. Anybody else have a question? State your name. Press *6 where you're from.
Christian. Hey, Christian.
Oh, who's next? One at a time.
Go ahead. I can go next.
Christian, Eric?
Eric, hey, go ahead.
All right. In claiming and proving, do we need to do anything beyond UCC 1 and 3? For example, do we need to send indentures to the party, to the other party? Do we need to disclose any of that since it's private anyway?
You don't have to put it in writing. It could be oral, And if it's being misconstrued, and then say, hey, I'm correcting any mistakes that are being made here.
So I guess the long and the short of it is the indenture is simply the expression of the way the trust operates.
Yeah, it's the intent and purpose of the grantor, and it could be so simple as, hey, I want my pen back. It could be as complicated as you wanted.
So, for example, in a mortgage situation, if we're claiming and proving and we're trying to keep from going to court, is there a need to send the indentures or simply express and then start ordering?
I like this second scenario you mentioned there better. I like to stay loose so I can shoot from the hip. As long as I'm still alive, I can always come back in and correct any misconstruement.
And I guess really what you're saying is your indentures can be fluid. They can change based on your needs.
Yeah. Right.
Okay. The only person that is bound to them is you, because you're the creator of it.
Down, who else is going to say what it was except me as the grantor? Once I write it down, now I've got it cut in stone. Now we got something that I can't back out of, or I could I got a harder time backing out of. Let's put it that way.
I think that's very important for everybody to know. So, if we were to simply express and then start ordering or directing or commanding, that would be a much better option. And then if they fail, then at that point, then they're just in breach, and the equity court is gonna find them guilty until they make a payment. It's that simple, right?
Right. Especially if they're coming at me with an offer. If I was trying to create an asset protection device to protect assets from anything under debtor-creditor, then I'm going to have to write all this stuff down. And then, I really don't think that's necessary, a trust. Because really got a trust already. Everything is in trust. What do I need another trust for asset protection? All I need to do is when they misconstrue it and they come at me under debtor creditor assumption, then I can rebut that and turn it into a trust and claim the trust, and and treat it that way.
Is there really a need to rebut it, or do we just simply express?
Well, maybe shouldn't have said rebut it, but I'm going to rebut it with the trust documents. I'm going to prove that claim it and prove that it is a trust. That's my rebuttal.
Okay, just to make sure if we need to go through that process.
Rebuttal to their debtor creditor offer. Does anybody else have a question?
Christian. How about, but let's say for an example, if you have someone that's where they've already foreclosed on a property, but that promissory note is still out there, you don't really want that note back. You want all the interest that has been earned and all the money that note or that note has accrued, haven't you? And if there's no way to really calculate how much it has, is that what you set in as far as like your damages if you're going after them to get that property back, to take it out of commerce?
Yeah, I have no idea what it's really worth, and I doubt whether or not they're going to give it back to me, and I doubt whether or not they're even going to tell me what it is worth. So I guess I'm going to have to do some discovery or put a value on it myself, maybe.
Yeah, especially if you've already defaulted them via notarial protest, you could pretty much set your own price to whatever it is. Especially if they're being non-compliant, so they're not rebutting a presumption of your own calculation of the value of the note.
Yeah. Or I could take the statutory rule, basically treble damages, which would be 4 times the value of the note.
Okay.
So it'd be the note plus 3?
Yeah, the note plus value plus 3. And then I have no idea, what was generated off of it. Might have to do some discovery on that.
Christian, you got a lot of helicopters in the background there?
Yeah, there's one down flying around here.
What are they, spraying chems?
I think it's the somebody down the street is causing some problems or something.
Oh.
We're going to see Christian on Cops episode next week.
Christian?
Yeah, go. Who's this?
It's Jacob again.
Hey, Jacob. Go ahead.
What relationship is a trust in a bankruptcy?
What? Title 11 is, and that is a trust relationship.
Huh?
Title 11 is bankruptcy, and that is a trust relationship.
So how do you use a Chapter 11 as a trust in a bankruptcy to your advantage in controlling the assets that are...
You didn't know it was a trust. You didn't express it to be a trust. And there again, you walked in there and they're going to say, well, you agreed to operate this under a Title 11, and that's what they're doing. They're operating this proceeding under Title 11. That's the rule.
If there's an entity that's in the middle of that, a gentleman, let's say in this case, and let's say there's a dozen several $million-dollar homes in it, and the bankruptcy judge is the trustee, which the party's not in the understanding that it is a trust that
Oh,
they're
wait a
in.
minute. Let's back up here. You signed up by filing bankruptcy Title 11 documents that basically appointed somebody other than the judge to be trustee. You did that. Whoever filed the documents.
Okay.
Now, if you're going to appoint the judge trustee, you better start changing some information around here.
The judge is not the trustee, forgive me, that's incorrect. So there is an appointed trustee in that particular case I'm talking about.
Right. And it's not the
And
judge.
so how does that person express the trust when they're in the middle of that, and that's what they did to themselves?
Well, what you did is you made a contract with them that you're going to do this trust proceeding according to Title 11. So if you don't like Title 11, they better do something different. And see, you screwed up because you didn't express it from the signature on the first documentation you filed.
So there's no way to help this guy that's in the middle of it?
Well, yeah, you can. You'd have to go back in and re-express it, and say that, hey, it was not my intent to form it under these rules, but how are you going to be under that court heading then?
Well, if he can get properties exempted, then can he express the trust on those items?
The property exempted.
Like in this case, he has several properties that he got exemptions for that didn't fall under the trustee, and so I suggested that he somehow re-express those those are in trust. Each individually has trust with a mortgage.
Again, it sounds like you're trying to protect your assets by holding in a trust, and then they're trying to get at all the assets.
Well, he did
bankruptcy.
Huh?
Does he get a foreclosure action before the bankruptcy? Title 11.
A bunch of them, Christian. Probably at least half a dozen of them. And then a half a dozen or more, he's not.
I think he should have come back in and where he first had the court actions and the foreclosures, treated them as trust right there.
Yeah, but he's already in the middle, so what does he do?
I don't know. I have to think about that. I don't.
Please think about
You
that.
lock yourself in under statutes and codes under Title 11, bankruptcy, trust. That's how you're going to operate that trust. The only thing I could think of is that you wanted to take and incorporate that whole case, that whole Title 11, and re-express it as being a different trust now under your rules. Yeah, we've got somebody in the background there, so could you, anybody's not speaking, could you press *6?
Anyway, he would take the whole case and re-express it as a different trust under his rules.
That's what I'm thinking, yeah, to get it out of Title 11. Re-express the whole thing. We got some terrible background. Is that, whoever the caller is of this two women in the background?
I agree. No such thing as but what a great password like really was.
Can we ask a question? Can you hear me?
Hold on, I had to press 6 to get muted here.
Did.
Or press *6 to unmute to speak.
Hey, Christian. This is Kevin from Maryland.
Hey, Kevin.
Hey, got a few questions. First of all, if I was getting a loan application and I find that loan application as grantor, and then from there I get to they give me the money, and from there on I would just continue on proving that it's a trust by doing the UCC1 and then assigning it with the UCC3, and then I guess then I would do a special trust deposit and make them the trustee to do the disbursement, I guess.
Yeah, that's basically the way it works.
Okay. So when I go and do that, I would just do the loan application. Now, I guess what I'm trying to get on the disbursement to understand, because I'm trying to follow on. I'm a little late trying to read the book and catch up with you guys. What's actually happening when they do the special deposit, the trust deposit? Am I getting the funds, or they're just actually paying the funds off and saying there is no more debt? I guess.
Well, actually, you're the one that's certifying there is no more debt because it's your trust residence paying the payment. You're the one that's making the directions, the decrees, the commands, the orders.
Okay. So I'm doing that in case of the IRS. Now, in case of someone going to court, when do you actually put the protective order in? Is that a motion you put in once you're in chambers and say, hey, or once you're on the public side and say,
of the beginning, because you want to put the protective order on the CCI information. That's what really sets it up as CCI information or trade secret information.
Okay. And then also going back in with the Social Security numbers. I know like people say, hey, I lost my Social Security card. I fill out another SS5 and I write down grantor. When I get the card back, I put down beneficiary. Will we need to go as far back as to even redo the SS4 for the EIN number? Because both of them are the same number. Just one linked to your straw man and one's your, I guess, you got it before you did the SS5. Do we need to do the EIN number as well on the SS4?
Redo the SS5 and the SS4 for the EIN number?
Yes.
And that would be for which entity?
Well, I guess however you write the number. If you write it one way, as the EIN number would be like two numbers, a dash, and then the rest of the numbers. It's the same number as the Social Security number, but technically you get an EIN before you make it into a Social Security number. So at some point, I guess when you got your birth trust and they made you a 14th Amendment citizen, you really got an EIN number, but then when they made the straw man, the all caps, they filled out an SS5. So I'm trying to figure out, do you need to clear up both of them, or is it just good enough to do the SS5?
Well, that SS5, that's the Social Security with the dashes in it.
Right. That's the way we write it, the Social Security number. Your EIN is the same exact number, except you write the first two numbers a dash, and then the rest of the numbers with no dash.
Yeah, but where do you get that number from? That's just patriot talk there.
Well,
that was issued by any particular entity, public entity.
Okay, I was under the impression that one you do with the SS4 and one you get with the SS5, but they're the same number.
Is there anybody out there that has actually got a number that's equivalent to their Social Security number with dashes put in a different area by filing an SS4? I don't hear anybody speaking up.
Okay. Thank you. That's all I have.
Christian?
Yeah.
I think that information that he was talking about on the Social Security number was something that was brought out in Patrick's information, and that was what we were supposed to put our birth certificate and W-8 IMY and BEN and a letter and a cover letter in to get them to get it into the correct
Yeah, I understand that, what you're saying. Yeah. But what I'm saying is that nobody's really filed an SS4 form and requested the same nomenclature numbers with just a different dash position.
Oh, I see. No, nobody's done that.
Yeah. Other than we're just saying to them, hey, put the dash in a different spot, and we call that our EIN number.
Well, I think that Patrick has said something about we could probably use the same number that they've given us because it's already on file. If they would reissue it as an EIN number, that's what they would have to do. And I think that's where...
yeah, but I don't know if anybody who's asked them to reissue the same numbers under a different sequence by the dash being in a different position.
Quite frankly, I don't know anybody that's gotten into the correct department to even talk to those who are in the authorities that can do that.
Yeah, nor do I think they can, or will they do that?
Well, that was my question the other day, and you brought up the post office because they deal on the private side. At least that's, I think, what I maybe I was assuming that, but
right.
But I think that's what.
That's why I understand too. That's the way I take it.
Okay. I do have a beginner question, a couple of them. This is Floyd, by the way. On the DIB, I forgot what that stands for.
Data Integrity Board.
Oh, okay.
And sometimes I say DIBH, that's the Data Integrity Board hearing.
Right. I knew what it was for, but I couldn't remember what it stood for.
Yeah. That could be a court case hearing. It could be a Treasury DIB hearing up there in Treasury.
Okay, now
other official, that's going to give you a ruling, say.
Okay,
be a notary. You can even have a notary being in a DIB hearing too.
All right. Okay. All right. I'll have to read more about that. Well, there's a lot of things I have to read more about anyway. On your Form 56. Now, when you accept, when you're creating a trust, now you have to put your case or whatever it is that you're working with, whether it's a traffic ticket, whether it's a mortgage or whatever it is that you're doing. That's the first thing that happens is you put that on the UCC1, correct?
Yeah, that's to claim it so that I have the ability to transfer it on a 3.
Okay, and then you return the information or whatever it is that they offer. You return that back to them with a Form 56.
No, not necessarily. I don't have to have a 56 unless I'm trying to create maybe an authorized representative as a co-trustee or with some kind of authority to operate under the trustee.
Okay, so it's basically how you sign your name that creates the you as the grantor and beneficiary.
Yeah, if I'm trying to express the trust by an indenture or writing, or to create evidence that I'm creating a trust, the first step is to give a qualified signature as by grantor, by trustee, or my beneficiary.
Okay, well then, when would you use the Form 56? I'm confused on that.
Okay, 56 could be used if I wanted to have, say, an agent, which could be operating as a co-trustee or operating under the trustee, so that agent has some kind of power given to him that he could, say, keep care of payments. So that 56 appointment, either from the trustee appointing this fellow or as grantor appointing, say, somebody to be working in conjunction with him.
So you would never use a Form 56, for example, in a court case appointing the judge as trustee with Form 56?
No, it's not really a fiduciary appointment for forming a trust. I would just be giving the appointment, per my paperwork.
I see. Okay. Well, okay, then, I'll have to maybe as I read this stuff and get into it more, I'll have a better understanding of that. Yeah.
Okay. Well, Gilbert's is a place to start. That book on Gilbert's Law and Trust.
Well, I've been reading that, and I haven't started from page 1 and just gone through it, but I've been trying to read everything that you've been giving us to read to keep up, with understanding on the different calls that we're on. So, anyway, okay. Well, that was what I wanted to kind of clear up tonight, anyway.
All right. Thanks.
Yeah. Thank you.
Hey, I've got a question.
Yes. Who's this again?
Hey, this is L in Nashville. How you doing tonight, Christian?
All right.
Great. Hey, my question is about the notarial process and as it relates to expressing the trust. I've read the Anderson's manual, PMBNOs, the UCC, some of the UCC sections, which I'm familiar with about notary process, as well as John Profat's book, I think from 1877. But anyway, they all talk about notaries doing protests for negotiable instruments, but it seemed like you mentioned at one point that, that was something different than, trust res property and so forth. And I was just wondering, first question, how can a notary, do a certificate if it doesn't involve a negotiable instrument? And also, all those manuals and books and sources that I just referenced talk about the giving someone like 3 days to respond. And it doesn't talk about giving them 15 days or giving them 20 days, giving them 30 days. And I was just wondering, where that giving more than 3 days for the process came from.
Well, I think it's 3 days was under debtor-creditor Regulation Z, 72 hours. 14 days came in, say, like under the 9-210 UCC. International comes in about 120 days. 30 days is like within courts. So it depends on what kind of law form you're trying to operate in. Okay. So the presentment by the notary, doesn't have to be a negotiable instrument under UCC. It could be just his hand and seal certifying his act and deed. And he did the presentment on some kind of documentation, and he got no response, say. Now, that doesn't have to be under UCC, because he can certify his own act that he did, a presentment. And he heard nothing back.
Okay, because everywhere I looked, every time I heard a presentment talked about for a notary, according to those sources, they were talking about doing a presentation on either a promissory note or a foreign bill of exchange.
Right. Which would fall under UCC Section 3-501, 503, and 505, under debtor credit.
Right. I didn't hear any type of presentment talked about in any fashion other than for negotiable instruments. And I was just wondering, is there a reference or an authority, in one of those sources or somewhere else? Or is it, just kind of people, assume, or people are using that, kind of creatively? Are they creating an additional power for notaries?
Well, I think the notary has more power than what he's aware of, and I think the statutes and codes are limiting him from what he actually can do. The National Pembino Handbook, pretty more explains, more fully the duties of what a notary can do.
Christian?
Yeah. Who's this?
The notary that you guys are talking about, can you use two signers instead of a notary? Two witnesses?
One of the facts that we use a notary is because the notary's certificate is going to be self-authenticating under rules of evidence. So yeah, you could use two signers. All I'm just trying to do is create some witnesses.
So if you had a trust that was two grantors and you had a trustee, and they gave a party a notice of breach of trust, and you had the grantor, the two grantors signing, and you had the trustee signing, would that be equal to a notice of presentment?
Yeah, they could certify what they had done,
Right.
and they're two witnesses. They're two records.
So if there's three signatures, the trustee is one for the trust, and they're bringing an action of a notice of breach of trust, and then the two grantors of that trust sign as the witnesses, that would be okay?
Well, now you got three witnesses.
Yeah, you have three.
Mm-hmm.
So that's okay too?
Or declaring that somebody breached the trust, you say?
Yes.
Well, then
So, yeah.
you're back to two witnesses, then, aren't you? Because who's breaching the trust? This trustee?
Well, in this case, it's a trust bringing an action against a trust, and so it's the trustee of one trust bringing an action against the trustee of another trust, but
All right.
the one bringing the notice to the other has the two grantors that are the grantors of that trust signing as the witnesses.
I see what you mean. Yeah, you could do it that way. That'd be three witnesses then.
Yeah, that's three. Okay, thank you.
Yes, Christian, the reason, I guess my main reason for asking the question was, I just want to be able to help protect my notary if, a question ever came from the governor or the Secretary of State or whomever would be trying to enforce, maybe a complaint against them from somebody that a particular process has been done on.
Right. I would look under my local notary rules and see if it doesn't say in there that notary can do other instruments. And if it says other instruments, then by statutes, you got your way out.
Oh, so you said that in the notary rules in Florida, it says other instruments?
Yeah, it does in Florida under 117, yeah, Florida statutes. It does says other instruments.
Okay, well, I'll check for Tennessee and then probably let you know it on somebody to call. Thanks for answering my question.
Okay, anybody else?
Yeah, Christian,
Who's it?
This is Floyd again.
Okay.
So I just, in order to get your correct email, all I do is just notice you that I want to be included in the Monday night.
A request to be a trust ambassador, yeah.
Yeah. Okay.
And it's an email request, one Christian at movingtitles.com.
Okay. Alrighty. And are you gonna start the workshop at the end of the month yet, or is that going to be set back a little bit?
Yeah, it's been about a week or so left. So we still got a little bit of time yet.
Okay. Well, I was just wondering, because I wanted to get my money in on time.
Okay, well, I'm sending everybody out the application.
When?
And all those that made a request will get the registration application.
Oh, okay.
Do you know when, Christian?
Well, I've been kind of trying to hold back and build up, a foundational base of knowledge and trying to build up a head of steam. Because, if we entered this right away, a lot of people didn't understand about the use of the UCC, the Moving Titles Platform. And if we got to go back and explain Moving Titles Platform before we start even getting it into trust, then, I'll certainly go ahead and do that, but, you guys would be wasting your time more. I'm sure everybody wants to get into the meat and potatoes of everything, and if we got to go back and teach basics, then, better to do that outside of the workshop than inside the workshop. Yeah. Okay, so we got one more call. It's getting kind of late. And anybody else have a question?
I have a question about, this is a little off the subjects that have been discussed. It's just, if a woman's going into the hospital to have a baby tomorrow or next week and doesn't know enough about how to claim the trust from the beginning, would putting 3 dots before the signature make the instrument incomplete, that the trust would not form?
Yeah, but if you don't know what to do after that point, then, what's the point?
Oh, I mean, you could do it at any time. It doesn't have to be right away.
Right. So I would say on a minimum, put 3 dots and then your signature. That would express the...
Okay, so are you saying that it would not make the instrument incomplete by doing that, so that they wouldn't be unable...
Well, it indicates that the instrument is incomplete, but then what's it incomplete? What's going to make it complete? They would have to know how to claim that there was a trust and how to have the evidence created so that they could prove the trust. So that's a starting point, yeah. But that would probably set stuff up that later on, if they could learn how and then utilize it to their advantage.
Okay, I'm just trying to make sure, would it be setting stuff up, or would it be that the people who are going to turn that into a keynote would not be able to do it because of the 3 dots? That's the bottom line of my question.
I don't know. If you get it by, they're probably not going to say anything. They just, I don't think that's going to cause any problems.
Okay. I didn't think so either, but because of what you said about incompleteness, I just wondered if they would silently take notice and not do anything with it.
I don't think so, not unless you expressed it that it was incomplete.
Okay.
Christian?
Yeah.
I've been in that situation a half a dozen times in the last 30 years. And, but the kids I've had, I've always delivered myself in my own hands at my own home. Mm-hmm. But one time, I had a complication, and I had to go in the hospital to have the placenta removed in emergency. And they would try to get you to sign forms, which that lady, she's talking about signing forms, and you wouldn't want to do that.
Why not?
Why?
Because you want to form a trust.
You already have a trust. You don't need to sign anything to form a trust.
Well, I haven't...
it's... They're just doing it to create the bonds that they can run in the background, that they can generate the funds until 18, and when that person should take over that trust. And by then everybody should be competent enough to be able to do the administration of the trust. But nobody is.
And I don't know any.
When I got in the hospital the one time in the emergency situation, and they kind of backed me into a corner where I wouldn't get emergency service when the mother's dying.
I wouldn't be afraid to go ahead and create this trust, because I think the system has been designed to operate as a duality. You really can't operate without this straw man or a straw man entity of some kind to interface into this fiction world that gives you access to the colorable titles that gets you the real things that you want, because that's just the way the system's been set up. We've set this system up ourselves that way, and the only problem with it is we just don't know how to operate it.
And I don't know anybody to go write those bonds for my niece,
Yes, I'm not too scared of creating this trust for somebody, because I think it's got to be that way. We just need to educate that person within the next 18 years so that they can, when they turn 18, 21, that they can take this thing over with, and run it.
Yeah, and that means the parents will take more interest, too, if they have to put 3 dots in front of their name.
Yeah, that would buy them the time that they would need to get this under the belt, the knowledge and the understanding, so they could come back in and take it over.
But guys, what is the Book of Life?
Well, we've got a trust there set up by God. God gave us the whole thing, but then,
But we don't know how to receive it. That's the problem.
Yeah, we're bad trustees. We don't know how to run it.
But what is the Book of Life?
Which one?
There's only one. The one where
There's
the breath.
one. Also
There's an
3.
eternal book of life, and there's an eternal birth life.
There's the one that records the breath of life that's given to each blood and flesh vessel that has a light inside that everybody calls a soul or spirit.
Right.
Book of Life. Doesn't that have any value?
Okay, but do you know someone who can go write bonds on that?
That breath of life, could that not be that your word is your bond, your breath is your bond?
Okay, I'm hearing you. I'm just wondering what your next step is. To formalize that in the present.
You don't think the secret hoop-de-doos have that?
Have what? A formal process to do it? Probably.
There's probably another thing out there that we don't know about.
Could be.
Could you just add a little more information there to what you're saying?
Well,
I'm not imagining.
I had a revelation a couple days ago about it, and that's why I was bringing it up to see if anybody else was spoken to, because usually the secret things of life are spoken to amongst a group, not to just one entity, not to one man.
Oh, I really resonate with what you're saying. I think that's
I think what I saw as a vision, to give you an idea, I was trying to understand and comprehend what it really means that our word is our bond. And I saw this, and I saw a vision. I saw a physical vision of of kind of an analogy of it, and it was my breath going on a piece of paper on lemon juice, putting lemon juice down as my signature, and then breathing my DNA into the lemon juice, and that's what I saw as the vision. So I'm just wondering if there's something that's missing where our actual, it really means that our actual word is our bond, but we just haven't figured out what that is.
It's your actions that confirms.
Yeah, it's definitely your actions. But
I think you'd have to be.
Nobody can act without a knowledge or understanding, and therefore we can't do the trusteeship because we don't know and understand.
Right.
Yeah, you'd have to be a.
What we're looking at is they're looking at our actions that confirms our intent. So we need to correct our actions and get our actions outside of debtor creditor, get it back under trust.
But Christian, are not our words our actions?
No, they're not. Because
action confirms your words. Yeah.
From a Christian family that includes generations of
Christian?
Yeah.
Yeah. This is Chris. I was invited a while back, but didn't get a confirmation from you. Should I be participating with Monday night's call?
Yeah, I wish you would. Yeah.
Okay, because I did, as you said, send in for the ambassador status or the teacher status, and I never heard anything back from you, so I didn't know what. I usually wait until I get confirmation.
Okay. Well, that's my fault there. So.
And don't worry about it. I know you're busy, and we love you, man. I know what it's like to be with as much activity as you got going on, so don't worry about any of it.
All right, thanks. Appreciate it.
do you
It's
need
getting kind of
another?
late. I really don't want to get this part of it, so, why don't we just talk about that on another call at another time?
Okay.
So, anybody got one final question? Close it down kind of early tonight.
Yeah, is Handy Summers, that's his Skype address?
Yeah, I believe it was. I think that's what Chris said it was, yeah.
Yeah. Would he mind if somebody else besides his friend contacted him for the recording of this? I wonder.
I don't know. Ask him. He was just on there.
He was just on? Oh.
Yeah, Chris, if you're recording it, why don't you send it over to me? Once I get up there, I'll put it on the website.
Was that Andy?
I didn't hear back. Maybe he got off the phone.
Christian?
Yeah.
Yeah, hi, this is Carlos. I have the last question, please. May I?
Okay, go ahead.
Okay, I'll do it real quick. Okay, we've been talking about the what is it? 210?
Yeah, 9-210A4.
Yes, it's 9-210A4, right. Now, when we go ahead and ask him for that information, what are we covering compared to the qualified written request? Are we covering the similar questions, or are we asking for the similar documentation?
I'm not quite understanding. I'm not following you. Were we asking for what now?
Okay, are we asking for the very similar info that when we ask him for a qualified written request?
Oh, qualified written request.
They're not typical. They're not the same, right?
Well, the 810 is just validation of the debt, basically.
Okay, so it's something that they're not going to reject us. They're rejecting all of mine. They're saying they don't have to, and that's out of the it's too burdensome. They're saying they don't have to do that. There's too much stuff that they're not legally bound to answer.
Well, they may say that, but then I'm going to certify that as being their dishonor, and that's going to give me that estoppel in the unclean hands doctrine.
Okay. But usually, what that a 9-210 cover? Do you have any idea?
Just the debt validation.
That's all. Okay, right. Okay. Now, going back to California, I found out that in one of my friends' foreclosure, I found out that in the county they did not record or file, or they did not transfer to the new trustee the power of sale. Therefore, he's selling the property with no power of sale, basically no right. Right? Now, I would like to address that also to them before they go ahead and sell it. But I just found out about it today in California. Well, I guess in all states, they must, the trustee who assigns the new trustee has to transfer the power of sale.
Well, it probably does, because look up in Black's Law 8th edition the definition of privity of estate.
Okay.
And that comes down to really, in the definition there, it talks about successor trust. And so there's a successor trust being formed. It's succeeding from the new trustee becomes the grantor when he sells it, and it just keeps on succeeding back and on and on and on. So really you have a successor trust.
Right, okay, yeah. But going back to the basic deed of trust, when they assign the new trustee to sell the property, this friend's property, they assign a new trustee to sell it, right? An attorney or another trustee?
Foreclosure now. That's not with the county.
Well, yeah, right. I'm sorry. That's what I meant on the foreclosure. They assigned a new trustee, but the trustee that assigned the new one, or the new trustee, to make a long story short, did not get the power to sell. That's my point.
Operation of law.
Right. They did not power to sell because they have to record it in the county. And I went to the county. I pulled all the documents from the property from day one, and there's no transfer of power to sale. So I said,
Is that listed in the statutes?
yeah, they have to. They have to. They have to. That's a must.
Okay, then that's a breach of the statute and code process and procedure. And
Right.
that would give you a violation there that you could come in and cancel the sale, say.
That's exactly what I'm going to do. That's exactly what I'm going to do. And it is in the statutes, and it is a must, and they violated Rule 115 also. Okay, last
So in the
question.
objection to the sale, you could put in as a cause of action in the objection to the sale that they breached the formality, the process, or the procedure that by statute they were supposed to do a recording of the trusteeship.
Right. Last question. Have you heard of the corporation SOLE, S-O-L-E?
Yes.
Okay. What do you think? Do you recommend it?
No, not really. No.
Okay. I'll go by your advice. Thank you. That's it.
Yeah, then under that 9-210A4, I was going to make a point here that it talks about the statement of accounting that the recipient approve or correct. And what I was doing was coming in by approving my statement that I'm saying that the account is zero.
Yeah, right.
When they don't come back within the 14 days, they have approved that the debt was already paid.
Okay.
It's zero.
Yeah, and what I did in another instance, I told them that I don't owe anything, and they had to prove it. Then I did an affidavit, and I had them prove it. They have to put point by point, and I gave them 14 days.
Mm-hmm.
Right?
And then in that same section there, it talks about and reasonably identify the transaction or relationship that is the subject of the request. And, well, I'm going to set this relationship to be a trust relationship.
Right. Exactly. Very good. All right, Christian. Thanks, and I guess good night.
Okay, appreciate it, guys.
We'll see you tomorrow.
Tomorrow, 8 o'clock. Yep.
Thanks.